Parliamentary immunity, also known as legislative immunity, is a system in which members of the parliament or legislature are granted partial immunity from prosecution. Before prosecuting, it is necessary that the immunity be removed, usually by a superior court of justice or by the parliament itself. This reduces the possibility of pressing a member of the parliament to change his or her vote by fear of prosecution. Legislators in countries using the Westminster system, such as the United Kingdom, are protected from civil action for slander and libel by parliamentary immunity whilst they are in the House. This protection is part of the privileges afforded the Houses of Parliament under the common law. Parliamentary immunity from criminal prosecution is not enjoyed by members of Parliament under the Westminster system. This lack of criminal immunity is derived from the key tenet of the British Constitution that all are equal before the law. In the run-up to the 2006 election in Canada, Conservative Party leader Stephen Harper denounced the ruling Liberal Party on the floor of the House of Commons, contending that the government ran a massive corruption ring using organized crime to defraud taxpayers. Although the Liberal Party had threatened to sue Harper if he repeats his allegation during the campaign, parliamentary immunity prevented them from taking legal action against his statements in the Commons. The 1988 Brazilian constitution grants parliamentary immunity to members of both the Chamber of Deputies and the Senate. Unlike other countries, Brazilian parliamentary immunity is also extended to crimes committed outside the parliamentarians' official duties. This does not apply for crimes committed before the Member of Parliament takes office. Members of Parliament can be arrested only for crimes if caught at the time of the criminal act in flagranti for a crime with no possibility of bail. These arrests can be overruled by a floor vote of the particular Parliament chamber that parliamentarian belongs to. Criminal proceedings may be suspended for crimes committed only after a parliamentarian begins his term of office, and requests for suspensions need to be approved by majority of members of Parliament. Members of the National Congress as well as other high-level politicians are prosecuted and judged exclusively by the Supreme Court, as opposed to the lower courts. As of 2007, no Brazilian politician has ever been convicted by the Supreme Federal Tribunal of any crime since parliamentary immunity was instituted in 1988. After the Mencello scandal in 2005, the Supreme Federal Tribunal surprised many when, on August 24, 2007, it accepted the indictments of 40 individuals, most of which are former or current federal deputies, all of which were allies of Brazilian President Luiz Inácio Lula da Silva. Members of the Parliament of France enjoy irresponsibility for what they did as parliamentarians, and partial inviolability, that is, severe restrictions for the police or justice to arrest or detain them. Both irresponsibility and inviolability are mandated by Article 26 of the Constitution of France. These dispositions are somewhat controversial. Following abuse of such privileges, Article 46 of Germany's constitution states, "At no time may a member be subjected to court proceedings or disciplinary action or otherwise called to account outside the Bundestag for a vote cast or for any speech or debate in the Bundestag or in any of its committees, with exceptions made for defamatory insults." The Bundestag can vote to lift immunity for specific members, and to allow prosecution in cases relating to alleged criminal activity. The Bundestag may also order that a detainment or prosecution of a member be suspended. The states of Germany also have similar procedures for their legislative bodies. Members of the Hellenic Parliament are immune from criminal prosecution, arrest or detention while in office, with the exception of crimes committed in flagranti delicto. They are also immune from having to provide any information to any authority regarding their legislative functions and deliberations. However, both the Constitution and the standing orders allow for the Public Prosecutor's Office to request from Parliament to lift an MP's immunity for a particular crime, with MPs deciding through open balloting. Alleged crimes committed by members of the Cabinet or the President of the Republic are first investigated by an ad hoc parliamentary committee, with MPs then voting on the committee's recommendations. Should Parliament determine that there is sufficient evidence for prosecution, an ad hoc special court is set up. Parliamentary immunity in Italy was reinstated in 1948 by the Constituent Assembly. to prevent cases such as Francesco Saverio Nitti, whose house was searched and ransacked by the fascist police in the fall of 1923. Giacomo Matteotti, murdered by fascists June 10, 1924 for his work as a deputy of Op.